Yes. Mara J. Galloway versus Tyler McKinney. These are motions regarding custody. Parties are present. Ms. Galloway is represented by Attorney Dennis. Before we proceed in this matter, as to the 18 file, as the court understands it, I'm going to confer with the President to be sure that Ms. Galloway in the 18 file, there's parenting time as the parties agree. There's no parenting time.
That is correct, Your Honor. There was also an order of consolidation for both the docket and the boarding services.
Right.
So the 2018 docket is our controlling docket number. I believe Ms. Galloway's pleadings had the 23 docket number. But the order of June 15, 2018 regarding Z granted the parties joint legal and joint physical custody with parenting time pursuant to the mutual agreement. The order of support entered May 31st of 2023 regarding W granted Ms. Galloway physical custody. Legal custody was not established, nor were any provisions included regarding parenting. Subsequently, a support order was entered on September 1st of 23. That order held the issue of child support in abeyance as the parties were residing together with the children at that time.
Also, in addition to all of that, there is a guardianship file in the probate court regarding the older child. And I understand the paternal grandmother is the appointed guardian of that child. We're only here today really dealing with the younger child.
So it'd be the 23 file?
Yes, 23 file.
That was part of the 18 file.
Yeah, I didn't know that at the time, and my client hadn't explained to me that there was a previous file involving that, but I just want the court to understand that we're here mainly today with what took place in regards to the youngest child in January. As my client filed her motion, the parties entered into a stipulated order back in May of 2023, and correctly that my client was awarded physical custody of that youngest child, and no mention at all regarding any type of visitation with the father. I asked my client about that this morning. I was just retained last night and seen the documents last evening. And there was no mention of father's visitation rights with this youngest child. And it was her belief that he may have been in jail at the time that this order was done, and it simply wasn't addressed because he was incarcerated. And that, as I understand, according to her, that he went into a rehab program and just recently got out on January 17th of this year. That may be why there wasn't visitation addressed at all in regards to father in that file. Certainly it's something that either you refer it for an investigation or father has to file a motion and we get this thing going in regards to visitation. But what we're really here for today is enforcement of that order, stipulated order, giving the custody of the youngest child to my client. And my client allowed, as she indicated,
the child's not with mother.
no, this is why we're here today. After he got out of rehab on January 17th, 2024, just here a couple weeks ago or less, my client allowed him to have visitation with the youngest child while she was working so that he could see the child. I think, in fact, he had both children with him. The other child, I think, is about maybe 8 or 9, somewhere in there. And when she got to work, apparently he contacted her and said, well, I'm not giving the kids back. So that's why we're here. My client went over that a day or two later with the police, tried to copy of the order, went over to talk to the defendant, tried to get his cooperation with the order, declined. The sheriff deputy or whoever was there that day chose not to do anything further in terms of enforcement of the order. Apparently there was some allegations about drugs in my client's house, and so she immediately submitted to a drug test, which was found negative. So she's tried to retrieve her children, but certainly this youngest child, she's tried to retrieve on her own using the only means available to do that. And for whatever his reasons are, the defendant is refusing to return either children to her. but we're mainly concerned today because of the guardianship. We'll deal with that one later, but we're mainly concerned with the youngest child as to why he's violating the court order. This really should be an order to show cause for criminal contempt because he's in violation of the order, the May order, or the May order that he just agreed to. So that's why we're here. We're asking the court to tell him, follow my order, return the child to the client and the plaintiff instead of doing what he's doing. He may have excuses, he may have reasons, everybody that violates court orders do. But they're not justifiable reasons. He's filed no motion. He's done nothing to try to modify the arrangement that was ordered and stipulated to here not very long ago, except using self-help because my client was kind enough basically to trust him and went over and provided him with the child, and now he's not following the order, not following the agreement they made, just doing what he wants because he feels like. Now, we want this child returned today in compliance with this court order. My client will go very straight from this courthouse and pick up this child in compliance with this order. I find out today he's got an order to show cause on Monday in front of you for I guess a probation violation. So he may be back in jail next week. I don't know anything about it. I haven't looked into it. I just happen to have found it this morning out on the docket out there. So we have that issue too. But the grandmother only has guardianship over the older child. And we're going to deal with that in front of Judge Harrington on the 21st of February. So that's my client filed already the motion. I'll be representing her that day at that motion regarding the older child. But in regards to this child, he's in violation of this order, and we want this child back today.
Sir, your response. All right, can we swear?
Yes.
Okay, go ahead, sir. Your response.
Well, as far as parenting time, I lived with them. Even when I got out of rehab, I was still living with them. My probation officer just did a home visit for me living there. I had my kids every single day. Yes, I had an addiction problem. I went to rehab. I just got out. And when I got out, I returned home and found a spoon in the bathroom that looks like it's been used for shooting up. And then there's a meth pipe in the drawer of the nightstand in the bedroom. And then as far as the drug test, I gave her sister this drug test for her to take. And I have to do these for my doctor for medications or whatever. But it looks like I don't know, it's hard to tell if the picture's blurry, but it looks like she failed for her metaphenes. And then she also, while I was gone in rehab, had moved 2 people in that are using meth.
Judge, I'm going to pose an objection here.
Excuse me.
I don't need any attorneys in the back room. I need to hear from Mr. Reed.
You know, he's referring to exhibits and sounds as though other people are telling him things. This is not stuff that he's seeing for himself. It sounds like, and he says the photograph looks like or might be. That's not evidence here. And then to go on and tell us what other people have said and done and might be doing.
No, I'm telling what I came home to.
Just wait.
It's hearsay, Judge, and he can't do it. Can't testify that way.
You saw these yourself?
What's that?
You saw?
Yeah, I'm the one that took these pictures.
Okay, so tell me what you saw.
Well, when I got home, I went to the bathroom, which my kids use, and I found a spoon on the counter in a bowl that this is a bad picture, but I even asked the officer that she had come over to my house.
Here we go again. I'm objecting because he's saying looks like, and now the officer said.
I would agree, that's hearsay. But there's a court order though in place. You understand that, correct?
Well, I did what I felt was necessary. I took my kids out of the home this shouldn't be where they could get to it.
What day did you discover this?
I don't know. I think it was last Thursday, Friday.
A week ago?
Yeah,
Is that a yes?
yes.
You have date on the photographs?
I do on my phone. I had to send them to my probation officer too. And she wanted dates and everything with them.
You don't have a date right now?
No, not with me right now.
How do you respond to her statement that she had taken a drug test according to her counsel and passed?
Where she took the drug test that I gave her sister to take. She didn't go nowhere for nobody to have it taken. Anybody could have pissed in that cup.
Oh, my sister.
I don't need to hear that.
I'm sorry.
Offer proof relative to the test you mentioned a moment ago, Mr. Reed.
Yes, you want my client to testify, Judge?
No, I want to hear from you. Well, you know what? I do want to hear from your client.
Very good.
Go ahead.
So my sister,
Just a moment, Marcia. Now, in your motion, and as I've indicated to the court today, you went over to the home of the defendant to try to retrieve your child. Is that
Yes.
correct? Right. Now, in regards to allegations of drug usage by you, what did you do after those allegations came to light?
I was given a drug test from my sister and she went into the bathroom and watched me pee into said cup.
Mhm.
And she sat there and watched with the 5-minute wait to see if I passed or not.
All right. And did it indicate positive for anything?
No.
All right. Was there any kind of test strip from that exam?
It had it on the bottle. There was like.
What
this
happened to
strip.
that after it was done?
I did throw it away after I had already showed it to the cops and everything to prove that I had failed or I had passed that drug test.
Okay, so after the test was done, who did you show it to?
I showed it to an officer. I showed it to my sister, my mother. We do have pictures of it, and I'm sure he does have the picture of the same drug test.
Okay.
Yes, because we did send it to him right away to let him know that I did pass that drug test.
And were you using drugs in the home?
No,
And you indicated in your motion that Mr. Kinney got out of rehab on the 17th of January?
yes,
All right. Was he in your home after that?
yes, to pack his things and to leave.
Right. And what day did you give your minor child to him?
I let him babysit on the 18th when I had to work 8 to 5.
Right. And
It's supposed to be in my home.
okay, were you able to retrieve the child that day?
No,
Where did you find the child?
at his grandmother's.
Did you try to retrieve the child?
Yes, and I called the law.
And were you able to?
No.
Did you speak with Mr. Kinney about getting the child back?
Yes,
And what did he say to you?
he told me that he was not going to give my child back to me.
All right, thank you. Any questions? Witness? Do you have any questions?
No, sir.
Defendant is alleging there was a spoon in your bathroom. Did you see that photograph?
Yes, it's a milk spoon from cereal. I had eaten cereal the night before and went to take dishes down and left it in the bathroom because I went to the restroom and forgot it in there. There was still milk residue and I had showed it to the officer at my home on the bottom of the spoon.
Is that what's depicted in the photograph?
It's a spoon. It's a cereal spoon from a milk it's cereal. I said, yeah, I was gonna give it to the officer to have it test. I'm sorry?
Any objection to the admission of that photograph?
No, have at it.
Let's see it.
Let's show them to Mr. Reed. All the photographs will have them marked and admitted.
Spoon?
All of them.
And can I, okay. This is his drug box that he had kept before he went to rehab. Yeah, that is my drug test that I had passed. Yeah. Oh, that must be that. Yeah, but there is a faint line there. I was on cold medicine, but nothing.
No objection.
Yeah.
All marked in the series. That's one. Actually, you can just submit them right to me, sir.
The spoon does have ashes on it.
But courts reviewed the exhibits. Permission to ask your client a few questions?
Sure, Judge.
Who else lives in the home?
It is me, my cousin Patrick, and then I do have my best friend Melissa living there. She's 8 months pregnant.
Patrick's last name?
Orlowski.
And how is he related to you or?
Kind of crazy. His mom and dad, that's my cousin.
Oh, it's your cousin?
Yeah. I mean, through marriage, but yeah, he's my cousin.
Melissa's last
Lewis,
name? L-O or L-E?
Lewis.
And any relation to?
No, that's just my best friend.
Any other questions of this individual?
There's more people involved in what she's saying.
Okay, well, if you wish to testify, we'll get to that in a bit. I'm wondering if you have any questions.
No.
Any other questions? Any further proof? No. Okay, sir, who do you wish to present or what evidence, other than the photographs, any witnesses or testimony?
I guess I don't really have evidence, but there was Melissa's boyfriend also staying in the house.
I don't oppose an objection as to how you would possibly know that.
Because I was living there.
Well,
Yeah, because of what I found.
Excuse me. It's not Pee Wee's Playhouse. This is a courtroom. You speak to the judge. You don't speak to the other party. Now, what's the boyfriend's name? You allege is living there or was living there.
Devin, I don't know if it's Daytrill or Jobson.
Okay. What's the issue with that individual?
He uses. That's who I used to get my drugs from.
Okay. Any questions? No. Argument.
The court order either means something or doesn't. And I've been doing this a long time too, and I know the court orders mean things. And if we allow people who are subject to those court orders to just do as they please because they feel like it, or they think something's going on, or they believe something's going on, without coming into this courtroom and trying to fix it themselves, we will have chaos. None of these orders are going to be followed by anybody. Because everybody in here who doesn't want to follow that order tomorrow morning is going to come up with an excuse. I don't have to follow it because that's not how this works. Our system doesn't operate like that. If this man believes there's justification to modify a court order, he can come in here any business day of the week and file a motion, and we can deal with it appropriately. You don't use self-help like this. You call Child Protective Services. They go out and investigate. I haven't heard that he did that. You call the police. They come over and investigate crimes going on in a home. He hasn't done that either. My client for one. The alleged drug addict is the one that called the police for help. That's what she did when he wouldn't return the child. So if he's got issues, then let's get on with it. Let's have a real court hearing, have an investigation done, and he can produce his proofs. Because so far, I haven't heard much of anything here about him thinking stuff is happening. And that's not good enough to violate this court order.
Kenny, this is your final argument. What would you like to tell them?
I honestly don't know. It's not stuff that I think. I mean, it's stuff that I know I was living there. It's what I came home to. I did what I felt was necessary and best for my children. I cared for my children. I would never put something in my children that something like this. Yes, I used and stuff, but it was always locked up and put away. It wasn't just laying around for the kids to get. I don't know. I felt like I did what was necessary. I should have called CPS and stuff, but I'm the father. I took them out of there, and I don't know. I just felt like I did what I had to do.
Okay. This is a motion regarding custody filed by the plaintiff in this case. The custody order relative to this minor child is very simple. That is that mother has physical custody. There's no mention of legal custody. And that's the problem the court has as well, because if there's no legal custody determination, the child's father, God forbid something happens to the child, the father has no authority to tend to the child and be mother, because she would be technically the only one, because there's no order in place regarding legal custody. So this is what the court is going to do. Number one, I'm going to order an investigation regarding legal custody in this matter. What's your position on parenting time? Should there be an investigation, Mr. Reed?
Yes, Judge, I think I mentioned that a moment ago. I think it all should be referred in front of the court.
And I think you want that too. You'd like to have something in writing regarding
Yes, sir.
custody and parenting time. So parenting time as well. I'm really concerned because there are allegations pointing both directions relative to substance use. And on one hand, I hear Father's Day, I took the child out because I see the spoon in the bathroom, looks like it has some white residue on it. And I'm not gonna have my child around that. Mom responds, well, it was just from cereal, dried milk. Why is it in the bathroom? I don't understand that. I have concerns, frankly. However, the court order is the court order. The child is being returned to mother forthwith. Otherwise, Mr. Reed, you are to draft an order relative to court's findings.
Judge, can we arrange a pickup time so there's no confusion today? 1 o'clock would be fine.
Can it happen at 1 o'clock today? Say yes.
Yes. And it'll be at where?
We're gonna do it right in the parking lot. Oh, both parties in the Bad X area.
Yes.
Right in the parking lot here behind the courthouse.
Courthouse. Very good, Judge.
It's all videotaped. Ms. Schultz.
Just to clarify, the friend of the court investigation is with regards to W only.
Right.
And the court is also referring to the child support. And is the court ordering the parties to participate in alternative dispute resolution if eligible?
I will. Thank you, everyone.
Thank you so much, Judge.
Sir, could you just stop for one moment? We're just gonna put a sticker on those photos.
Nothing but the truth, so help you God.
Yes.
Time out as we let the computer reboot.
I'm sorry.
Hands down. Mr. Yan, this is your motion for custody. If I'm correct, the parties have joint legal custody, mother has physical custody. That was entered on October 16, 2023. The parenting time is the parties mutually agree. Could you explain to the court what the proper cause or change in circumstance is to warrant a review of custody in this case?
Well, basically, I would like to see my son more often than what I do. Obviously, with my job, it's kind of hard to get a set scheduled time. So there are times where I ask to come over and they try to reschedule, but it doesn't always work out, or I get told no, or I can't come over whenever I want to. And yeah.
Okay. So it's not I believe your motion reads that you wish to go equal time.
Yeah.
Is that correct?
Yes.
Okay. So other than wanting more time, what's the reason that we should review these custody factors when it was already decided back in October?
Because I am getting basically magnified by her. And
You're getting what?
Magnified, like under a microscope.
Oh,
Looked at basically under a microscope, no matter what I do at the house, visiting my son, or have like a long time. It doesn't matter. It just seems like they're magnifying, justifying whatever I do with them.
I appreciate you not using the name of your child. Your son is very young, correct?
8 months.
8 months. Okay. Anything else?
No.
Why don't you have a seat over here, Mr. Reed? Do you have any questions?
I do not, Judge. Thank you.
Okay. You're all set? Do you wish to call
Yes,
any
sir.
witnesses or anything like that?
What was that?
Do you wish to call any witnesses or anything like
I have
that?
my mom. She's in the first room right now too.
Okay. Is that an opening at all?
Oh, yes, Judge, I do, and I've already filed a written response to the motion. And quite frankly, this motion is premature at best. We have a stipulated order that the parties entered into back on October 16th, basically 3 months ago. Probably the ink is dry. And this gentleman has now filed a motion asking for 50-50 custody. And you've heard the reason, which is that the reason why he's asked for more custody time. It doesn't meet the threshold requirement of changing circumstances to even warrant this court conducting a hearing on this matter. If that's his proofs, that's all it's going to show. That doesn't rise to the level of changing custody, quite frankly, at all, let alone 50-50. Now, the parties made an agreement, and it's a very clear agreement. And in that, custody is granted to my client, sole physical as custody to my client, but legal custody. And the parties are to have parenting time as mutually agreed upon. He agreed to that. That's what he asked for. And it's right there. And the court can see from our response, the second supplemental response that I filed the other day has actually a text message between the plaintiff and the defendant where this is what he wants, Tuesdays and Thursdays at her house. That's what he asked for. And the court can see from a rather detailed diary that my client has been keeping. We gave you a typed version, but there's a handwritten version here if the court wants to see it, that my client kept, showing every visit that the gentleman has had with this child since actually July 11th, 2023, way before the court order was even entered into. In addition to these regular visits, my client has supplied family members of his with visitation with this child. She's not trying to keep the child away from the family. And you can see by this running diary that this gentleman comes by often, every few days, if not every other day, and he's there. One of the problems that we have, is his lack of ability to take care of an 8-month-old baby. What he's demonstrating in my client's home when he's there is troubling and worrisome to her. He will play on his telephone. The longest that I've seen, he actually held his own child was 5 minutes. And when the child was fussing, he immediately gave the child back to mother. He has to be prompted to change the child's diaper when he's there. He has difficulty feeding the child. And my client is concerned that he just doesn't have the skill set here to take an 8-month-old baby out into the world in his care. And until recently, he didn't have a car seat, from what we know. And he's going to take this child to some unknown babysitter while whatever he does, he does. That's what his motion says. And there's multiple problems with that. Besides the evidential issue with that, which I think this motion should simply be dismissed at this point in time, we have the factual issues. He just isn't there yet as a young father. This is his only child, from what I understand. He isn't quite there yet to be taking care of this child on his own. And what we often do in cases like this, and perhaps you've done too, judges, we'll do a step up basis. Let's do this for a little while, and then if everything goes well, then we'll jump up to a little more and jump up to a little more until eventually he gets to a point where he's able to take child, go on about his life, and have visitation as a normal type of relationship, but not with an 8-month-old baby that he has no experience really taking care of. I don't think he's pled sufficient facts to even warrant a hearing or an investigation at this point in time, because we have minimal requirements in Michigan before the court even has to entertain a motion to modify a custody order. These orders are certainly not final, but they're final until the person meets the statutory requirements in order to have a change of custody. And he hasn't done it yet. He hasn't even pled it yet. And we think the motion should be dismissed at this point in time, Judge, because he hasn't met the threshold requirement.
Very well, thank you. Any other response?
No.
All right. The issue before the court, whenever there's an issue relative to custody under the law, there must be a showing of either proper cause or change in circumstance. Proper cause can mean basically one or more appropriate grounds considering how that has a significant effect on the child, or you can look at what's known as change of circumstance, and that's the cases by part BODVARKA. And basically what that one says is that since the entry of the last custody order here would have been October 16th, yes, 23. So we look from October 16th to 23 moving forward, what may be happening. What I read in your motion really sounds like a parenting time issue and not a custody issue. But you did not request parenting time, you requested custody. You have joint legal custody, physical custody is with mother. And the court, you have to establish by preponderance of the evidence where the conditions surrounding custody of the minor child have or could have a significant effect on the child's well-being. And that things have essentially materially changed. What we have here sounds like, and don't take this the wrong way, Mom, this could be a mom that's very, very protective regarding a father who is new to it. I'm not assuming Mom is a seasoned veteran either, but at the end of the day, all we have here is I'm not seeing the child enough, and that's not a proper basis for custody. It could be a parenting time motion, but you cannot file that.
Yes,
So,
there is a.
oh, there is a parenting time. You are right. You are right.
However, the parenting time motion asks for 50%.
Right. Which that would be a change in custody. Anytime that you change the custodial environment where majority of the time now switches and it's equal, then you have to go to the custody elements, custody factors. But there is a motion for parenting time. The standard is lessened under the Shade case. And at this point in time, we are going to keep status quo, but I do find a change in circumstance, parenting time only, relative to the parenting time schedule, because it says as the parties mutually agree, and it doesn't sound like anyone's agreeing from what I've read in the motion. So I do find a change in circumstance relative to parenting time. I'm going to refer this matter to the court for an investigation regarding parenting time. As I stated before, though, the current order shall remain in full force and effect. Parenting time as the party are, parenting time will be as the parties mutually agree. And at that point in time, Ms. Schultz and her office will conduct an investigation and make a recommendation as to parenting time only. Custody is denied, parenting time is granted.
Right. Will they meet with the front of the court today, or will that be in the future?
I think it will be in the future.
It will be in the future. Is the court also ordering alternatives to the resolution?
I would order that as well.
Thank you.
So you'll have questionnaire forms and information that you'll need to fill out. There may be interviews, there may be requests for letters, documentation. Don't ignore it. Don't ignore it. Make sure you provide all that information. The court can make a recommendation.
If the parties wish, they may pick up their investigation packets.
All you're about to give in this case is the truth, the whole
Thank you.
truth, nothing but
Thank
the
you.
truth, so help you God.
Yes, I do.
Yes? Thank you.
Yes.
Ms. Schultz or Ms. Schultz? This is one, if I'm not mistaken, that we did a couple months ago.
Yeah, that is correct, Your Honor.
There's an ongoing investigation right now.
That is also correct, Your Honor. So on October 27th of 2023, an order was entered as to K, granting parties joint legal custody as well as joint physical custody, and requiring that the minor child be placed in Mr. Gothram's care. We subsequently modified the parenting time schedule with the referral order that entered on December 27th, 2023. That order granted Ms. Wilson Gothro parenting time every weekend to be exercised on Saturday or Sunday as the parties agree. If they cannot agree, parenting time is to be on Saturdays from noon until.
Okay, thank you. All right. Ms. Wilson Gothro, there's an investigation ongoing right now, and that's regarding custody as well. Right.
All issues are on the table.
All issues.
The parties are both scheduled for interviews with our office next week. Both parties have submitted completed questionnaires at this time.
Wonderful, thank you. Ms. Wilson Gothro, I read your motion and it appears to be regarding primarily medical concerns, but what is your reason that you want to change custody again, despite the fact that we're in an interim spot waiting for the investigation to be done?
Right. No, I understand that there's an investigation going on. Right now it is 100% medical. Other than the fact that it was a default judgment on October the 20th due to my hospital stay. Mr. Gothro is not able whatsoever to provide the medical attention that Caden needs after he's moved out there. It's with myself and my daughter, and all of a sudden it's gone for, I'm not even sure why. I still have no idea how it could get like that. I have,
Okay.
It's been a change in circumstances. I have procured, a home. I'm doing contractor's license. There's zero chance that Mr. Gothro can attend it's a rigorous recovery.
Sir, your response.
The rigorous recovery is well over exaggerated, Your Honor. The doc from his first surgery, which was a much more intensive surgery that he's going to have this next week, was after a few days, if the kid's up to feels like it, to start regaining normal activities. As for medicines, it was Tylenol, ibuprofen every 2 hours is needed. I've taken off a whole week. I have 7-day stretch I can take off to help take care of him. I need more time. The lawyer says no problem. Take as much as you need. I'm more than well capable of helping him recover from this upcoming surgery, which is a less invasive surgery as the last one he had.
Now, Ms. Wilson Gothro had claimed in her motion that one, you scheduled the appointment and that causes problems. How do you respond?
What it was, Your Honor, was when
at his post-surgery appointment from his last surgery, they wanted to reschedule the next one. The doc says, well, 3 months he'll be healed up really well, and 6 months he'll be fully healed up. Let's set it for that date. I says, that date is just before New Year's. I says, well, if my insurance and paid time off doesn't renew it renews at the first of the year. I says, if it renews at first year is okay. And she said, just give me a call, no problem, we'll reschedule. So that's what I did. I just said, what's your next available date? It was, just after January, well, it'll be next week. So that's what we did. Reschedule it just because of my insurance and paid time off. First. Nothing to do with needing reoccurring surgery. That's obscene, Your Honor, to have him in there every 6 months to have some surgery. Other than regular hearing tests and a checkup every now and again to make sure growth hasn't returned in his other ear. There's no other surgeries after this. Maybe later in life if this cyst growth comes back, but we can't count on that.
Ms. Wilson-Gothro, any final comment?
Yes, absolutely. So Mr. Gothro states that there was only Tylenol and Motrin. That's how much he knows. He had left the first time. There's pets in his home. Caden has to have drops, antibiotics. It has to be tended to every single time it drains, which is almost constantly. I sent all the paperwork in to say the restrictions that he has, and he has this every 6 months. It's very serious until his growth plates close. I mean, him taking a week off is nothing. It takes months for Caden to recover, and he doesn't know that because he wasn't present last time.
All right, court's had the opportunity to hear respective arguments of the parties involved in this case. There is an ongoing investigation by the front court relative to determining custody and or parenting time. The court doesn't find any proper cause or change in circumstance, but it will be considered as a part of the final order once we get to that point in time, once the investigation is complete. The motion is respected. Thank you. That'll be all. This is the defendant's motion, and Trevor, you may proceed.
Thank you, Your Honor. Judge, probably one of the more difficult things is to discuss what a court perhaps has the power and or authority to do, and I don't say that disrespectfully. I understand, having practiced law for 47 years in court, rely on documents that they are provided. Suit in this matter was filed on May 12th. I don't know when the conflict was determined, but at some point, Mr. Salins apparently determined that he had a conflict, and I believe the counsel filed his appearance in early August. The summons was going to expire on August 12th, and the counsel did, in fact, enter a substitution on August 2nd. The summons was going to expire on August 12th, and on August 8th, the court received a affidavit request for issuance of the second summons. And the basis was upon information and belief, Mr. Salins did not have success in serving the defendants with the summons and complaint. This court, based upon that, issued an order authorizing the second summons. MCR 2.102 requires that there be, before a second summons can be issued, that there be a showing of due diligence in attempting to serve the original summons. We now know from counsel's answer that there was never an attempt to serve the summons. Apparently, early on, Mr. Salins realized he had a conflict. I have no problem with Mr. Salins trying to find substitute counsel, but the court rule doesn't say that you have to exercise due diligence in finding substitute counsel. It says you have to exercise due diligence in attempting to serve the summons. There was no attempt to serve the summons, and more importantly, the catchphrase "upon information and belief," which counsel provided, means quite frankly nothing, because he doesn't indicate. Had he indicated, Mr. Salins revealed to me that he has had difficulty serving the summons, that would be appropriate. But upon information and belief, counsel's own answer says he had no information and belief because he didn't know. So, Your Honor, the basis for providing you the affidavit of an attempt to serve the summons was improper. The court issued an order relying on counsel. And with all due respect, the order should not have been entered because the facts weren't there before the court. There was no showing of due diligence from looking at the documents the court was presented with. There was no showing of due diligence in attempting to serve my clients. Therefore, Your Honor, I would ask, and the answer is real simple to what to do on this. I've been involved in this situation. You get involved in a new case, summons hasn't been served, and what do you do at the 11th hour? Dismiss the case or let the clerk dismiss it because it's going to be automatic. And for $175, file a new case. You haven't lost any ground. Instead, we're here now. This is very important to us. So, Judge, I would ask that the court find that there was not a sufficient showing of due diligence in attempting to serve the summons, set aside the court's order, quash the summons, and therefore, once the second summons is quashed, the first summons expires, and as a matter of law, the case is dismissed without prejudice. Should the court disagree with me, which has happened before, not this court, but which has happened before, Judge, we then have to show good cause and a meritorious defense for the default being entered. Upon receiving the summons, the second summons, which my client did receive, they went and spoke and got off the papers and spoke with the local attorney. They thought at that point, because the local attorney had represented them previously in a PPO matter filed by Ms. Koch, they felt that he was handling the case. They did stop in several times to see the attorney, and of course, unfortunately, counsel are busy and nothing took place. They thought the case was being handled. Obviously, we find out when a default gets entered, it wasn't being handled. So, Judge, we believe that is sufficient good cause to set the default aside, sufficient good cause. As to a meritorious defense, this complaint indicates that starting in 2013, my clients had harassed the plaintiff. Doesn't say how, says they stole sand. They live on Lake Huron. There's a small, I don't know if it would be a creek or a gully that for some reason when it rains, it fills with water, sometimes backs into my client's house. The lake fills up the mouth of that, so my client goes out and digs it out. It's on his property, he digs it out. Once in a while, Mother Nature will cause a tree to fall down, and he'll cut that up. That's the stolen sand, that's the tree, and then there's just general harassment since 2013. Mind you, Your Honor, that my clients really didn't have much relationship with the defendant, with the plaintiff, but as I indicated in our affidavit, my client's affidavit, on Easter Sunday, 2018, they received a phone call. If we look at the calendar, we'll see that the following day, the annual tax sale deadline goes dead and you lose your property. This plaintiff needed $12,000. She called her neighbors, these defendants, who she claims have been harassing her for the last 5 years, and says, I need $12,000 or I'm going to lose my house. What they do? They gave her $12,000. Later, they got a mortgage. They gave her $12,000. And the reason I'm bringing this up, Judge, is the meritorious defense issue. If the court looks at the facts, we stole sand from the beach, opening up the mouth of a creek. We cut a tree down that fell on the property, and we've harassed her by giving her $12,000. I hope to be able to harass people and get money from them like that. So do we have a meritorious defense here? Absolutely. More importantly, I don't even know what the statute of limitations is, because the only date set forth in this summons is since 2013. So, Your Honor, working backwards, we have a meritorious defense. We certainly have good cause. And should someone say that my client was neglectful or attorney neglect, and I'm not suggesting there is I think there's perhaps a miscommunication between my client and their prior counsel. But if the court finds it under MCR 2.602 that that's not good cause, ironically, the statute also allows the court to look at MCR 2.612, which has a potpourri of areas, and one of them is just basically fairness. Judge, we have a right to defend this case. The way the complaint is, the court couldn't even, with all due respect, couldn't even give a judgment because who knows what they're even asking for. And so the easy way out is to set the default aside. The tough side out is to say the order never should have been entered because the affidavit wasn't acceptable, and therefore I'm setting aside the order, quashing the second summons, and dismissing the case. And I ask that the court go for the latter. Counsel can go ahead and file a case right immediately thereafter. Pay $175, start a new case. I can't, because the dismissal would be without prejudice. So, Judge, I don't know if the court has any other questions. Sorry to pack it together so much, but I tried to put it in my brief and spell it out. Thank you.
Thank you, Your Honor. First and foremost, if the court were inclined to dismiss, I would just stipulate to setting the default aside, because I don't, that would put us a couple steps behind. We'd have to file a new filing fee, which would be cost to my client. So if the court were inclined to do that, I would stipulate to set the default aside to save costs and save time, because counsel is right. I would then have to refile and file a new filing fee. Your Honor, the case law that's been cited, it's been adequately briefed. I do recognize that we prefer meritorious resolutions of cases, and defaults obviously are not that. So I know there's a strong public policy in favor of that. But the defendants do admit that they were served with the complaint, and that they had time to respond to it, the second summons and complaint, and they failed to do that. So I think the issue becomes, is it good cause that they had this misunderstanding with their prior attorney? I think the meritorious defense affidavit was very lengthy. I could see how the court might say there are some defenses here. So I think the rub comes to, is that excusable neglect on part of the defendants, and that thinking that this lawyer was handling it. I know most courts, Your Honor, do set these things aside because we do prefer to have cases litigated on their merits, and not have winners, so to speak, on procedural issues. So I would defer to the court's discretion on that, obviously. But I would request that the court we're going to just dismiss the case, that the court allow us to just enter into a stipulated order, setting aside the default, providing maybe 14, 21 days for the defendants to serve their responsive pleadings, and then we can be off and rolling with this.
Your Honor, I would rather have the dismissal. This, my appearing here today and my thoroughly briefed pleadings cost more than $175. And if I was able to ask the party store owner what the winning lotto numbers are, and if they're wrong, I can get my dollar back, that's also a nice way to go. And I'm not being sarcastic, but the fact of the matter is that the second summons was erroneous. And even if you want to get into the default issue, that's why the court rule does allow 2.612, because I'm not sitting here bashing prior counsel because I think there was a communication issue. But the fact of the matter is, I think I have put together ad nauseum the relevant facts in this case. And of course, to just add one little part, why did my clients wait after the default was entered? My client's wife had a stroke. So there's a lot going on, but this case never should have gotten going beyond the issuance of the second summons. I would ask that the court set aside the order, quash the summons, dismiss the case. You can write a check for $175. I'll pay the postage. I'll accept service.
Mr. Miles, I never heard anything regarding the due diligence in attempting to serve.
Yes, Your Honor. So Mr. Salins, as I had indicated in the brief, he originally was representing the plaintiffs. He discovered that there was a conflict that could not be waived. I'm not sure what that was. I think he had maybe represented the defendants in a similar or different matter. And so he then referred the case to me. When I talked to him, I asked him if they had been served, and he said they had not been served yet. I had assumed he had made attempts at that point, and that's why and again, I would never put anything misleading in a pleading, Judge. I literally thought he had made attempts to serve the defendants. Otherwise, I wouldn't have put that in there. And then I didn't even learn until after this motion was filed, because then we went back and looked at emails and things. There was a follow-up email after I talked to Mr. Salins from my assistant to his assistant, indicating that there were no attempts actually made at service before the case was transferred, before I filed my appearance. So but that's correct. That's correct that there were no attempts to serve the first summons.
Okay, I've heard enough based upon that. Based upon that, under considering the court rule as well, I find no due diligence in attempting to serve the defendants in this case. It could have been just a matter of kind of holding on to it to see how things go, but court rule is the court rule. I'm granting the relief to the defendants in this case.
I'll be setting aside the order and
Quashing the second summons in the specific case without prejudice.
I'll submit an order in 7 days.
That'll be all.
Thank you.
Thank you.
Thank you, Judge.
Kevin Shepka. Welcome. This is Ms. Benjamin's motion regarding parenting time. The parties are present. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Ma'am.
All right, you may put your hands down. Again, to both parents, again, do not refer to the first name of the child. Initials are appropriate. As I understand it, and Ms. Schultz can correct me if I'm wrong, as of August 21st of 2019, the parties have joint legal and joint physical custody. Parenting time is as mutually agreed.
Yes, that is correct, Your Honor. However, it is my understanding that the parties may also have additional children not in common, not subject to this docket.
There is, but she just didn't have insurance. I'm working on getting her insurance, so that's why she wasn't in on this. I'm assuming they're all three our children.
I don't know that the court can do anything because there would be appropriate motions or pleadings to amend the case file to include those other children. But I just wish to place that on the record that our case is only with regard to death, but my understanding is there are additional children.
But can I address them?
Yeah.
Okay, that's how we'll do it. That's all we can do. Is Benjamin,
May I ask why they're not on this case then?
This case is from 2019. Those children were not born at the time they were murdered.
Okay.
There need to be appropriate steps taken to either add the children to this existing case
Okay.
or create a separate case for those
I
children.
think I did put their, when I came and did it, I think I put all three of their names on it. When I came and filled everything out.
There may be additional actions pending with the prosecuting attorney's office.
Okay.
The file in the matter today before the court, if I may, Your Honor.
Sure,
is with the
please.
friend of the court office.
Okay.
So until such time as an order is entered for us to enforce, the friend of the court records do not reflect any additional.
Okay, so is that something I can do?
That is, it's an establishment versus enforcement function within the support program.
Okay.
so in other words, until the children are subject to an order, the friend of the court cannot be involved.
Okay.
But we can involve W.
Okay.
What are you requesting?
I just want 50-50. I want to know that I'm going to be able to get my kids when
Well, we only can.
right, well, yeah, W. When said time is, because I don't want to know if I'm going to get them like a week from now, 2 weeks from now, like I want to know.
Where's W currently?
At my, at his grandpa's, my
Okay.
father's.
When's the last time you had seen the child?
3 days ago? 2 or 3 days ago.
So the parties have joint legal, joint physical. Basically, it comes down to the custodial time, which is another word for parenting time, and you want to go 50-50.
Yes.
How about you, sir?
I mean, I think we need to get all three involved and then make all three a case and not split our children and individualize one or the other. Because technically right now, she has all power 24/7 and she does whatever she wants with the kids. And I've only seen them once in the last 25 days. So there should be she has no concern on when she's going to get her kids because she gets them when she wants them.
Well, here's what it comes down to, though. Joint legal, joint physical, parenting time as agreed. I know there are other children involved. And it's up to both of you to get the other children into this file, so to speak, or at least into another file. But she's asking that you just, is it week on, week off?
I would like to do 3 days on and 3 days off as I still breastfeed my youngest. I mean, we're only talking
Okay,
about
no,
W,
if-
but I would like to do 3 days on and 3 days off.
Technically, she has no house, no vehicle, just started her first day of job. So I've been very lenient with it staying how it is. And I think it should either stay how it is or, I mean,
Well, how it is right now is there's no parenting time.
Yeah, I'm
well,
every
right,
week.
and she gets them whenever she wants them. And it's I guess I just don't understand the purpose of it because it's very simple and they all three go together and like, it's really not an issue.
So hypothetically speaking, if the court had the authority, there are 3 total children?
Yes.
Correct.
If there were 3 total children, what would you like to see regarding the arrangement between the 2 of you?
Well, once she has her own house and vehicle and stable and on her feet, then we can go 50-50, yes,
Well, it
absolutely.
looks like she's living in a residence in Caseville. Whose residence is that?
It was 5150.
Excuse me.
Oh, go ahead.
That's her mom's house and she's not, basically, it's not suitable for her to be there with the children. She said it many times.
Why didn't you file a motion to get the children back if it was not suitable?
Because we technically lived together and she did something she wasn't supposed to do, so then it split us up. So she went to her mom's house.
Now I see.
Yeah, so I mean, the whole problem is we've been together for 11 years of our entire childhood, and she made a mistake, and she thought that the better choice was just to leave and run away to her mom's and cause an entire scene with our children and the whole 9 yards. So now, since she technically never got a job when we were together, and I technically supported her the entire time, now she thinks that she's just can take whatever she wants of mine in a sense and do whatever she wants.
How old is W?
4. Your Honor, but I have a rent agreement right here that states I could rent his home and his car.
And she forgot to put, she didn't want to put it on the paper, but we definitely have texting and communication, and I have her on video. I'd have to find the video, but it is on one of them. But we agreed that we'd work on our relationship, and she can stay and rent the house and the vehicle. And we can go back and forth with our children, 50-50, week on, week off, but we can't involve other, like the opposite sex, until we go at least 3 or 4 months working on our relationship with counseling or whatever it need be. But we've been together for 11 years of our life.
Okay, well, we're not gonna go all the way back in time here. but
Right,
I can only address W right now.
right.
That's all I can do. W is 4. Obviously, W is preschool.
Yes. He
And
goes Tuesday, Wednesday, and Thursday, 8 to 10. He's only 2 hours a day.
when did you, so you're living with mother currently?
I was living in that home until his rental home until he changed the locks. I have a rental agreement here. The cops even stated I could be there. He changed the locks on me, so I had to go to my first day of work. I'm wearing the same clothes as yesterday because I have no clothes because he
So
changed
there's
the
a landlord
locks.
tenant dispute between the two of you?
Yeah, kind of, because I won't get back together with them.
No,
Well, wait, you don't need to go there.
right,
We don't need to go there.
it's not that.
Before all heck broke loose,
I have police reports on all of it too.
again, before heck broke loose on this, on your relationship,
Mhm.
what was the arrangement with W?
What happened was he did something he wasn't supposed to.
No. What was the arrangement?
Oh,
lived
we were
together
living
24
You
together.
lived together.
That was 3 years ago when everything happened.
Okay, so when you lived together,
Yes.
W was with both of you.
Yes,
So when mom was alone, or if dad was working, for instance, mom would be with W, right?
correct.
And if mom were working, I don't know if she was working or not, but if she were
I did work
working,
at Fiddler's Green.
the child would be with dad, right?
Correct.
Okay.
At our house.
No, Your Honor. There was many times where I had to drive all the way to Caseville to my mother's because I worked midnight. So I had to drive all the way to Caseville during snowstorms and all that because he wouldn't keep our children. And I have proof of that, but I would have to get it.
Okay.
There was many times I had to go there. I lived only a mile away from my work. I had to go all the way to Caseville, drive all the way back. And then in the morning,
So where do you live right now?
I was residing at 7095.
That's
And then he changed the locks.
Then he changed the lock.
Yes.
Where do you put your head at night now since he changed the lock?
Since I haven't had my kids, I was staying at my friend Tara's, because that's where the cop said best to be. And
Is
if,
that home suitable for a 4-year-old?
no, I'm going to go back to my mother's, which that home is very suitable. There, they will have their own room. I'm gonna go back to my mom's, obviously. I just stayed there for the last 2 days because it was easy because I had to go to work. I work at Bad X, and
What is your work schedule?
Monday, Wednesday, and Thursday, 8 to 4. And I currently have a job offer at the hospital too for another job.
Okay. Sir, any concern with maternal grandmother's home?
Yes, absolutely.
What's that?
Well, they only have 1 bedroom and there's 3 kids and 1 adult in the 1 bedroom. So that's an entire house in 1 bedroom. They also have 3 huge giant Doberman dogs that are supposed to be living in that bedroom that scratch my kids. They always have marks on them every single time, every day. And it's not suitable because her mom takes care of the kids for her. And I have that on video. She admitted it too one
What's
day.
wrong with that?
Well, she said she can't raise her children because her mom raises them for her. She wants to be an adult and she wants to do better for her children, but she can't at her mom's house.
Did you change the locks on the apartment?
We have a secondary, well, we have a
Is that a
vacation.
yes or no?
Yes,
Why?
because she broke the agreement.
But I did, there's nothing.
She was there for 2
Okay, well, I'm
days.
not gonna get into a contract. I've heard enough.
Right, it's
Here's
not.
what's happening on an interim basis until all the children are together. The parties already have joint physical custody. It'll be week on, week off. Either the exchange date is Friday or it's Monday. Or actually, pick an exchange day. Friday, Saturday, Sunday.
We do Sunday probably, so he's not interfering with.
Yes, Sunday.
What time?
Yeah, I mean, I would really like to be a little bit flexible, but so.
Well, if the parties agree on something else, that's fine, but I want a baseline.
Well, 6, I would be able to feed them before I take them over
I
to
would say
Evans.
7 because 6 is right in the middle of dinner normally, or just finishing dinner. And we live a half hour apart. So by the time we get done
He's
with
saying
dinner,
7.
get ourselves cleaned up, 7 is.
Is 7 okay? I'm not trying to twist your arm.
That's fine.
I'm gonna make it 6:30.
Okay.
6:30 exchange time. Here's the rule for transportation. You want your child, you pick up your child.
Right.
And when the child be returned, the child is to be returned by the parent who is bringing the child back to their.
Now, may I ask what the address of the
We're
child?
going there next.
Okay.
The meeting place.
I
No,
would
the
like
address
to,
the
I would like
child's
to meet
living
in a
at.
public place if that's okay.
We are addressing parenting time only at this time.
So I don't get to know where my child lives?
It's week on, week off, sir.
Right, but where's she staying? She doesn't have a house.
I do have a home to go to.
She stated she's going to be staying at her mother's home.
I thought, okay, I thought we stated that wasn't suitable, but,
Well, you said that was not.
well, she said it's not too, like,
No, she
I can
said,
find the
no,
video.
sir, Mr. Shemka, she was
Okay.
talking about her girlfriends.
no, she was talking about, I have a
Okay,
video.
don't argue with the
I'm
court,
sorry.
sir. Don't argue with the court,
All
sir. Where do we meet for the pickup and drop off?
I would like a public place so I don't have to be alone with him.
I see Bad Axe for one and in Caseville for the other.
Okay. In front of the cop station in Caseville.
You have transportation?
I have the Jeep that I'm driving right now.
Okay,
that
you
I
have
have
a
a rental
vehicle?
agreement with him on.
Oh, you don't have,
The
you
rental agreements. with-
I will have a vehicle. I have a
have
doc.
transportation available?
Yes, I do.
And you do as well, sir?
Yes, sir.
Okay. Okay, well, if it's pickup, you can either pick 2 locations or 1 middle location. What would be easier?
If he's coming to me to pick up the kids, we could meet at the sheriff's department here, there, and then sheriff's department here. Because I don't want to be alone with him in a house because he'll corner me.
Okay, again, let's be adult about this, everyone. So, Dad, you have the child right now?
My father does.
But you're in
Yes.
custody of the child. Okay,
Correct.
so the exchange will be Sunday, 6:30, and you are to meet right here behind the sheriff's office in the parking lot area. There are cameras there for the exchange.
Thank you.
Can I say one?
Just a moment.
Okay,
And when it comes time, when the child's with mom, the exchange will be at the Caseville Police Department in the parking lot there. Go ahead, sir, you got a question?
yeah, so she, filed this motion on what, like, the 6th or something of January? Somewhere around there.
January 9th.
January 9th, okay. So from January 2nd to January 23rd, she held them all in every single way, shape, form, and how from me. And I literally asked every single day, and we had plans, and she never gave me any time with me.
Right, but did you file a motion?
Well, no, she
No,
already.
my question, did you file a motion?
No, because she
Okay,
hasn't
that's the
filed
problem.
one.
You
She
can
already
file a
filed.
motion when that issue arises.
So I can file a motion on her motion?
You can file any motion you
Oh,
wish,
well,
absolutely. But in the interim, what we are doing on an interim basis is this arrangement for the one child. Hopefully, the parties can get together on the remaining children so we can have one court order to address all of them. So, any questions about my order? Any questions about my order?
I was just getting at the fact that I've only had my kid for.
Sir, you're dwelling over information that we've already addressed.
So you're saying that she gets him Sunday for the entire next week?
Correct. And then the next week, you get the child.
Okay, I just only got him one day today, and I've been in here all day, but 23 days in a row, and I spent my one first day with him in here, and now I don't get him again for another entire week.
Well, when did you get the child this week?
Yesterday.
Okay. And have you had the child before January 9th?
Yeah, January 1st when we lived together.
Okay. Okay, well, that's my order.
Okay.
That's all. Thank you. This is, I believe it is Ms. Arntz's, yes, it's Ms. Arntz's objection to the friend of the court recommendation. Sir, your name's James Hatcher?
Correct.
And Miss, your name?
Dana Fick.
Ms. Fick, and you are? Ms. Arntz, you are objecting, correct?
Yes.
And Ms. Fick, you are actually a guardian.
Correct.
Ms. Schultz, can I have some information?
Your Honor, there were 2 orders of support that were entered in these actions. Originally, the co-defendants each had a separate docket. The order of support for Ms. Arntz entered on December 10th, 2021 with regard to the minor children J, L, and B. That order granted Ms. Fick physical custody and control for the duration of the guardianship. Subsequently, Ms. Arntz had filed a custody motion. The court referred the issues of custody, parenting time, and support to the friend of the court on August 29th, 2023. Our office had attempted to complete that process. However, neither Ms. Fick nor Ms. Arntz returned any written documentation to our office. We had in-person interviews scheduled with both parties. Ms. Fick was home with sick children on the day of her interview. We had advised that we would reschedule once her questionnaire was received. Ms. Arntz contacted our office on the day of her interview. It indicated she was ill. Again, we advised we would reschedule the interview upon receipt of the questionnaire. We subsequently received no information from either party. On November 28th, a friend of the court recommendation was issued as to all issues based on outside source information.
All right. Okay.
Can I add one thing? Mine was by Zoom and I was present for it. Mine was scheduled by Zoom and I was present. I did not have the paperwork, but I was present for the meeting.
All right. But you're not objecting.
No, I just wanted to clarify. That's all. Mine wasn't in person.
Basis of your objection. You're testifying, you may be seated. Oh, I'm sorry, tell the court, why are you objecting?
I did turn in all of the paperwork except for one packet, I guess is missing, because I did confirm with them about the interview. I got COVID and so did my youngest. And I guess it was my confusion. I figured they were gonna call me to schedule an interview, set up a time that works for them and me. And one day I got the papers in the mail. Plus the name on everything. And as soon as I got it, I came back here and they wouldn't give me the packet until court meeting. But I did turn in everything but one packet.
Sure.
Your Honor, I received a release of information, a domestic violence screening form, a reference questionnaire, which is intended to be provided to third parties, friends, neighbors, employers, those types of individuals filled out by Ms. Arntz. I did not receive her custody questionnaire, which is nearly 20 pages long and addresses all of the best interest factors.
That's the need to say that.
She did turn in support documentation, but I did not receive a written questionnaire from Ms. Fick or Ms. Arntz.
Any other comment?
I went to go get it, but like I said, until the court, they said there was nothing that they could do.
When did you go and attempt to submit the information again or get another packet?
Last week.
The investigation was completed. Schultz, when was it completed?
November 28th.
November 28th. We need testimony regarding the recommendation.
So the court would like at least the summary.
I would. I don't even know what the recommendation is myself. Ms. Schultz, you prepared a recommendation?
Yes, sir.
What is your recommendation?
The friend of the court had recommended that the issue of legal custody of the 3 children be preserved until the further order of this court. That Ms. Fick continue to be granted sole physical custody for the duration of the limited guardianships or until the further order of the court. That Ms. Arntz be granted parenting time on the second weekend of each month to be exercised from Friday at 6 p.m. until Sunday at 6 p.m. That she also be granted parenting time any other times that the parties may mutually agree. That she be granted, Ms. Arntz be granted reasonable rights of talk time. That if the parties are unable to agree, that talk time may be exercised on Tuesdays and Thursdays at 7 p.m. and may include the use of telephone calls, text messages, or video conferencing, including Skype, FaceTime, or other similar applications. That the parties will equally share transportation of the children. If they cannot agree on how to divide that responsibility, the non-custodial parent is responsible for transport at the beginning of parenting time and the custodial parent at the end of parenting time. that the parties may elect to have a responsible adult transport the children for parenting time, with a responsible adult being defined as an individual over the age of 18 who is known to the children. Advance notice is to be provided whenever arrangements for a non-parent to transport are made for visitation. That the parties will utilize the close application for purposes of non-emergency communication, including the calendar feature for purposes of the parenting time schedule and the children's activities and appointments. That the children be enrolled in individual counseling services and that those services continue at the discretion of the treating therapist. And that Ms. Arntz continue to pay child support in the amount of $621 per month for the child.
Any questions of officials?
Yeah, again, I have not had a single thing that is supposed to be granted to me for my children. That has not happened. And the last incident where the police were called was on the October week of the 14th is my son and my daughter's share birthday. So that Saturday I went down and I drove 6 hours with my father to get told to go here, to here, to here, to here in the city. I did it for 6 hours. Not to see them, I have to go wait at her house, 2 hours for an officer to trade down the incident.
Okay, but my question, did you have any questions for Ms. Schultz based on a recommendation?
The child support, I thought that was supposed to be 75 a week.
The guardianship placement plan provided for $75 per month for the 3 children for each of the co-defendants. However, when we ran support most recently, the calculation is based on the Michigan child support formula, not a probate court order.
I did have 2 jobs and I only work 1 now as well.
What a good job.
At least, I know at least a few months ago, I did let them know in the office next door that I stopped employment at Sony in my cornerstone.
Do you wish to present any other proofs or any other evidence? Obviously, the only party objecting to this case is this matter, Mrs. Arntz, and the friend of the court has made its recommendation based upon the information provided. Based upon all of that, and I'm assuming, Ms. Schultz, your recommendation was based upon the 12 factors.
Absolutely. The child custody 12 child custody best interest factors, as well as the parenting time factors, were considered to the greatest extent possible.
And based upon that, the court has no testimony or no evidence otherwise to contradict that. And as a result, the motion or the objection to the friend of the court recommendation is respectfully denied.